Good morning, folks, and welcome to the third meeting of the Referendum Scotland Bill Committee. Can I ask everyone who's got a mobile phone switched on, if you still have, to switch it off, please, so we don't have any unnecessary interruptions. Stuart Maxwell has sent his apologies in for this particular meeting, and Bill Kidd is attending in his place today, so welcome, Bill, to your first meeting of the Referendum Bill Committee. I'm not sure it will be your last over the course of the next or the forthcoming months that we'll be looking at these issues. That takes us to item 1 on the agenda, Declaration of Interests. I wonder if Bill Kidd wants to declare any interests that you might have.
No specific relevant interest to declare at this point.
That takes us to item 2 on the agenda, the subordinate legislation oral evidence sessions that we have. Can I just, as a preliminary, mention to the committee that this week, earlier on the Tuesday, the Subordinate Legislation Committee considered the draft order and no points to raise, and its report has now been published. With that being said, can I welcome our first panel of witnesses here this morning? Very much a warm welcome to the Scottish Parliament and our deliberations, to Professor Aileen McHarg, who is the Professor of Public Law at the University of Strathclyde, and to Alan Trench, who is the Constitution Unit at the University College of London and also at the University of Edinburgh. Do either of you want to make a short opening remarks? Or are you happy to get into questions? Or
happy to take questions.
Straight into questions. Okay. In that case, is there any questions? Who wants to begin the questions? James.
Okay. Thank you, convener, and welcome to the committee. Thanks for coming along to gather evidence. I'd like to start by, just exploring your view of the document which precedes the Section 30 order, which is known as the Edinburgh Agreement, and perhaps if you can explain what your understanding is of the legal standing of that document.
On you go. Yes, Professor, by all means.
Thank you. The legal standing has been subject to some discussion. I think my view is that it has no legal standing. The view of the UK government, at least, is that it's not intended to create legal relations, and I imagine that is the view of the Scottish government as well. I believe it appears on their website with other concorda and other memoranda of understanding, and they are generally stated not to be legally binding. There is, I think, a slight doubt, but it's only a very, very slight doubt. An argument has been put forward in relation to the other concorda that they could create legitimate expectations which would be legally enforceable. But my view on that is that's a very tenuous argument. I can't really see any situation in which a court would uphold a substantive legitimate expectation based on the memorandum of agreement.
Strange.
I think I would largely, but not entirely, agree. It's certainly the case that the document is intended not to create legal relations. That is the case generally for intergovernmental agreements and memoranda. The overarching memorandum of understanding in its various editions since 1999 has always said very loudly and clearly this document does not create any legal relations between the parties. That is equally true around the world. Similar agreements between various levels or orders of government are designed to be not binding in law, but to be binding politically and in honour. It would be quite difficult for the courts to engage. I think I would be slightly less certain than Professor McHarg that the courts would not find a legitimate expectation in this case. I think if the Parliament were to pass legislation here that were materially at variance with the provisions of the agreement, that might start to raise an issue where a legitimate expectation could become involved. And that takes one into a yet further and thorny difficulty because, of course, the agreement is between two governments. It isn't between the legislatures. So there is a further question of the extent to which this agreement can bind this Parliament, rather than can bind the Scottish Government, which signed it.
Did you get any supplementaries on that particular point?
Yeah, just on to drill down on a specific point then, which is something that has been discussed. For views then offered, as has been by the First Minister, the Deputy First Minister and the Lord Advocate, that this document, the Edinburgh Agreement, is a legitimate trigger in order to either release legal advice or to authorise the release of legal advice on, for example, the issue of membership of the EU post the independence referendum. Is there any legitimacy for advancing that position in legal terms?
I'm personally rather sceptical about the effect of this agreement in relation to that, because the agreement, in a sense, changes nothing. The agreement does not alter any legal position. The legal position will change once the Section 30 order is made. That will bring the holding of a referendum in the way that's provided for in the Section 30 order within the legislative powers of this Parliament. That is a meaningful change in the powers of the Scottish Parliament and therefore the responsibilities of the Scottish Government in relation to that. I can't see that the agreement itself meaningfully acts as a change in circumstance.
Under then, in that case, I mean, the Lord Advocate answered a question yesterday in Parliament in this regard, where he said, in laying out an agreed route to independence, provided the basis upon which specific legal advice could be sought. Further, up until that point, it was possible the referendum could be subject to court proceedings with all the uncertainty that entails. It was possible the court would rule that this Parliament did not have the power to hold a referendum, in which case the issue would be academic. Following the signing of the Edinburgh Agreement, there will be a lawful referendum, so the uncertainty has been removed.
No, there is an undertaking that uncertainty will be removed. Uncertainty has not yet been removed. Because there is no Section 30 order, therefore there are no powers in this place yet.
Can I just add to that? I mean, I think what Alan said is absolutely right. It's the passing of the Section 30 order that will make a legal difference. But as a more general proposition, and I say this with some trepidation because I haven't given a great deal of thought to this specifically, but I would have thought that the taking of legal advice on whether or not something can be done must be different from any other kind of act because, in order to decide whether or not you have the power to do something, a prior stage in doing that is seeking advice on the issue. So I think it is a somewhat, I'm not saying it's necessarily wrong, but it seems a strange argument to say that it was impossible to seek legal advice until this point.
Annabel, you had other areas out the general. Can I just touch on the general agreement just now, and I'll come back to other areas, and I'll come to Annabel.
Okay, yeah, and good morning, and it's great to see you both here. I have a question for both of you, which looks at the Edinburgh Agreement, paragraph 30, the last sentence thereof, and perhaps I'll just read that out for the benefit of others. The two governments are committed to continue to work together constructively in the light of the outcome, whatever it is, in the best interests of the people of Scotland and of the rest of the United Kingdom. Could I ask both of you to comment on what you feel that means?
I favour the short straw in answering first. I think it means everything and it means nothing. But I think it's potentially the most important provision in the agreement because what it says in black and white is what one would hope to be the case in a more general sense, which is a commitment to mutual cooperation and mutual respect. And one of the great concerns I would have about the whole of the referendum process is what will happen afterward. Because it is inevitable that in a referendum such as the sort that the Section 30 order presages and the agreement presages, one side will win and one will lose. And there will be a large number of Scots who will have voted for the side that loses. So a commitment that both governments will work together to ensure a proper outcome and proper process for the referendum, and whatever may happen thereafter, seems to me to be very important.
I think I would agree with that. I mean, it doesn't say very much other than is already in the memoranda of understanding. And as Alan said, I mean, it can be read in two ways. Either we have a yes vote, in which case there is a commitment to continue negotiating, but I don't think anything more than that. So not to renege on any sense that the outcome of a referendum is politically binding, but equally, if there's a no vote, that government continues, so that the necessary interaction between the two levels of government will continue in a good spirit.
Good morning. This is a question for Mr. Trench, and thank you for the memorandum which you submitted to the committee. I'm interested in teasing out what you're saying in paragraph 8 of your memorandum. And in this, you're talking about the role of the Electoral Commission, mentioned in the intergovernmental agreement, but not, of course, mentioned in the Section 30 order. And I'm just anxious to establish what you mean when you say, while it would be open to the Parliament to pass a bill that wasn't in compliance with the agreement, but that would raise numerous risks. And you say that the way to avoid these risks is to involve the Electoral Commission. Well, first of all, can I clarify, what are the risks? Is this the threat that the result of the referendum could be placed in question and subject to challenge?
I think it creates two sets of risks. One set are broadly legal or constitutional, and one set are more broadly political. The legal or constitutional risk goes back to the point where we started, which is this question of whether there is a legitimate expectation created by the Edinburgh Agreement that the referendum will proceed in certain ways, in particular with regard to the involvement of the Electoral Commission, which is now incorporated into that agreement, but not in the Section 30 order. And that is clearly an issue of considerable importance to the UK government and to the Conservative, Lib Dem and Labour parties. They've each expressed the importance in various places, or people from them have expressed the importance of the involvement of the Electoral Commission as they would see it as a fair ring holder and regulator of the referendum. The political consequence is that you undermine the respect with which the result of the referendum can be held after it has been held, because the referendum is then not seen by a substantial proportion of the population as having been a fair referendum. And I think that the fairness and the perception of fairness becomes central to the respect which the losing side as well as the winning side will have for the outcome.
Supplementary to that, Convener, I'm grateful, Mr. Trench, and is it your proposition that the insurance policy against such unfortunate outcomes would be the involvement of the Electoral Commission? That would avoid handbags at dawn.
I wouldn't put it as bluntly as the Electoral Commission or handbags at dawn, but I think the Electoral Commission's involvement acts as a powerful guarantor to many on the pro-union side that the referendum's outcome can be respected, and that the process that leads to the referendum and involves up to and including polling day is a fair process.
Fair from what you're saying, that you don't have a kind of pick and mix with the Electoral Commission. You either have it involved or you don't.
I think that pretty much has to be the position. I mean, if we can go back a stage, in 2010 the Scottish Government produced a consultation paper for the referendum, which proposed the creation of an ad hoc regulatory commission, and this was one of the points that was particularly used to criticise the Scottish Government's referendum plans at that time. Now, given that paper was based on the inherent powers of the Scottish Parliament to call an independence referendum and no Section 30 order, it had no power to engage with the Electoral Commission as far as I can see. Or rather, the Electoral Commission had no power to engage with the referendum that would have been called in those circumstances. So that would have been a legal problem with involving the Electoral Commission under that approach to holding the referendum, which is why the Section 30 order solves a very significant problem. The question that was proposed in February 2010 was, in my view, an exceptionally cumbersome and unwieldy question that would have failed any measure of intelligibility imposed by any regulator, whether the proposed Scottish Referendum Commission or the Electoral Commission. It's perhaps brave to second guess or first guess what the Commission might say, but I found it very hard to look at that question and to think that it would pass an intelligibility test. Even I struggled to understand what exactly it was asking me to agree to, because the wording was so convoluted, to try and bring it within the powers of the Scottish Parliament. You are able, if you have the Electoral Commission involved, if you have a Section 30 order, to have a question that asks a real question, not a question that dodges around the main concerns. And you are then able to have the Electoral Commission produce advice about that. And I think the advice about intelligibility is going to be one of the key elements of ensuring that the outcome can be seen as fair.
You want to say at this stage before I bring Patricia Ferguson in?
Well, just to say that, I mean, I agree that there is a need for an independent guarantor of the fairness of the process. Whether or not it has to be the Electoral Commission is a slightly different issue. I can see I can see two sets of arguments why you might want to make it the Electoral Commission rather than an ad hoc body. One of which is we have a body that does this. Why go to the trouble of inventing a new one? And secondly, is the question of trust. Given that we do have a body that is capable of doing this, why would you not want to use it? So I can see the argument for that. I'm not sure about Alan's argument over legality question. I don't see why, on the assumption that the Scottish Parliament had the inherent power to call this referendum, which is a debatable question, but assuming it did, I don't see why it could not have empowered the Electoral Commission to act. I don't see the fact that the Electoral Commission is established by UK legislation necessarily precludes it having additional functions conferred on it, but that might be something that requires further debate. Anyway, it's an irrelevant question.
It becomes an irrelevant question.
Kind of moved on a bit. Patricia.
Thank you, Convener. Good morning. To pursue that particular angle a little bit further, I did note in the submission that you made to the committee, Mr Trench, that at point 7 you suggest that the main way by which clarity, fairness and decisiveness will be established, other than by the vote itself, is through the involvement of the Electoral Commission in regulating the referendum and advising on the referendum question. Are you content that the Section 30 order allows the Electoral Commission to fulfil that role as it stands?
I think I am, yes. I think the Electoral Commission is able to fulfil that role, and the order, of course, does not mention the Electoral Commission, but the agreement does, so which is why we discussed the relationship between the two, and why it has a particular concrete point.
To follow up on that then, do you believe that the Electoral Management Board has any role in the process, or should have any role in the process?
I haven't thought about that enough. I'd have to duck that question at this point, I'm afraid.
You want to make any comment on that particular point, Professor Tavish?
Thank you, Convener. Can I, Mr Trench, just go back to the points you were making earlier on the Electoral Commission's precise role, and in particular use the word involvement. What do you mean by involvement? Do you mean that their advice would be binding? It would be guidance that Parliament would have to deal with and accept?
Well, the question of who takes the advice is going to be a varied one. It's partly going to be advice to the Parliament, and it's partly going to be advice to government, the Scottish Government.
Yeah.
I think that the implication of where we are is the Electoral Commission should play the role in relation to the independence referendum that it's played in relation to, for example, referendums in England about whether to have elected mayors, or the referendum in 2004 about regional government in the north east of England, or perhaps most usefully of all, the role that it played in relation to the referendum in Wales in March last year about the extension of the National Assembly's legislative powers. Now, there were problems with how that referendum worked, and there is scope for argument about the extent to which the Commission could be blamed for those. The Commission itself thinks that it did as good a job as could be done in the circumstances. And the circumstances were certainly unfavourable circumstances, given the nature of the referendum issue there, and the fact that there was no organisation that wished to be the no campaign, so they could not designate a campaigning body on either side.
Is that we have an agreement which states the Electoral Commission will be the body, so the rest is academic.
Yeah.
So the point is, will the guidance that the Electoral Commission produce for Parliament, we're not the government, we're the Parliament, will it be binding on us? Do you think it should be binding on us? Should we take it in the way in which other places have, which is never to have once gone against the advice of the Electoral Commission?
It is. I think it falls into that category of a body that gives advice rather than provides a direction, but whose advice is sufficiently authoritative that it should normally be followed, and one would expect it to be followed.
Indeed, and you can't envisage the circumstances where Parliament wouldn't follow that advice.
I think if you were to get to the point where Parliament didn't follow that advice, that would raise very serious problems for the conduct of the referendum and for the respect for the outcome afterward.
Thank you.
Can you tell me, has the UK government ever not taken the advice of the Electoral Commission, or not the Parliament, but the government?
Not so far as I know. And in the example that I know best, which is the Welsh referendum, the Secretary of State had proposed a referendum question. The Commission went away and carried out its work to formulate an alternative question. And when it formulated its alternative question, which was quite different to the Secretary of State adopted that question. Immediately it was published.
But in terms of where we are in the agreement, though, I mean, the agreement is quite clear, if I'm clear about it, that is, that both the UK government and the Scottish government have said that, and accept that the Electoral Commission will be the body involved in the questioning of the testing issues, the general guidelines around the referendum, but the Electoral Management Board will actually be responsible for the delivery of the mechanics of the referendum on the ground.
The Electoral Commission would never undertake the conduct of the mechanics of a referendum. That would always be delegated to the local electoral mechanisms, whatever they may be, the process of returning officers and so forth in England. You have and in Wales, you have a rather more considered approach following the problems with the 2007 election and the Gould report.
If we can move on to another area, I think Rob Gibson wanted to...
Following on from the legitimate expectations raised by the Edinburgh Agreement, do the terms of the Edinburgh Agreement ensure that the Section 30 order will be clear and decisive and beyond successful legal challenge?
I think so. I mean, I have seen it suggested that a Section 30 order could be challenged as being ultra vires the Scotland Act 1998. And of course, it is a piece of delegated legislation, so it is open to judicial review in principle. However, what is the ground? What's the ground on which you can challenge it? I mean, I don't... The argument that I've seen run is that somehow you would be reading into the Scotland Act 1998 an implied... restriction on the ability to devolve any question about the Constitution or the Union in particular, but that doesn't appear on the face of the legislation. And I think the political reality of the situation is that no court is going to run with that argument. They've been given a free pass from a very difficult legal issue, and I cannot see them not gratefully taking that. So I think it doesn't stand a chance, which doesn't mean to say that somebody might not try. They might try, but I wouldn't give them any chances of success.
Yes, I would agree. I find it inconceivable that you could bring a legal challenge to this particular sort of an order, particularly given that the order is the very mechanism by which you can vary the protected enactments and the reserved matters in Schedules 4 and 5 to the Scotland Act. And particularly because in order for the order to be made, it will have been approved by the House of Commons, the House of Lords and by the Scottish Parliament. You can get no clearer and more emphatic an endorsement by elected institutions than that. And the courts are rightly very reluctant to challenge instruments that have had that sort of level of endorsement by elected bodies.
I want to remain on the issue of the specifics of the order. I think, Linda, you had a particular issue there.
Yeah, I think Patricia and I were interested in broadcasting and the free mail shots, etc., the transfer of powers that the order allows for that to happen for this referendum. Do you think it's going to be clear enough for the Scottish Parliament to properly discuss and come to good decisions about how we should move forward in terms of, for example, election expenditure, in terms of broadcasting, and in terms of the mail shots and the content that go through people's doors?
It would appear to me so, but did you have any particular and specific concern?
I think it was back to, as a non-legal bod, hearing folk like yourselves going on about legalities, etc. And then you read other parts of it and say, well, this is just a transfer. Is there anything within this transfer of powers to allow the broadcasting, to allow the mail shots, which is part of the democracy all round the referendum? Is there anything to stop the Parliament, deciding what this Parliament believes to be best?
Yes, if you were to decide that there should be no mail shots and no broadcasting.
Right. Yeah, I think that's right. This is there would be two potential ways of doing this. One would be, the problem here is that communications and postal services are reserved. So there could have been, as in the general exception to the reservation of the Union, there could have been a general exception to the reservation of communications and postal services, in which case it would have been up to the Scottish Parliament to then devise the rules. But what has been done, actually, is a very specific application of the relevant sections of PAPERA. So I don't think there is any scope for deviation from that by the Scottish Parliament. I think you just have to accept that.
And equally, that is really rather a good thing. This was a particular problem in the Welsh context. Because of the absence of designated yes and no campaigns, that meant that the level of publicity that was given to the referendum was negligible. And in those circumstances, I think there was about a 35% turnout. That was actually quite a good turnout in the circumstances, given the very limited publicity that there had been for the referendum there.
Patrick, I think you were interested in the order and some of the things it contained or didn't contain, so I'll let you come on stage.
Thank you, Convener. Good morning. Already during the discussion, several members have talked about the question, and I think you've talked about the question in your answers. Does it matter that in Part 3 of the order the word question isn't used, only the sense that two responses are allowable, and that in a later part it uses the term question? Does that make a difference? The first seems to imply that two alternative statements could be offered. The second seems to imply that a question must be asked.
So what you're getting at is the possibility that the question could be something like, do you want independence or do you want further devolution? Is that what you're concerned about?
It does seem that two responses that are allowable, only two responses. It doesn't specify that one of those must be the status quo. It also doesn't seem to me to specify what level of independence might be talked about. Could one of the questions, if we pass this order, for example, be, should Scotland have independence over domestic legislation, taxes and benefits?
Well, if you look at Section 3 of the order, the exception to the the exception to the reservation is a referendum on the independence of Scotland. Okay, so it's going to have
several things.
It can mean
already.
We're
looking at a government which seems to be proposing independence except in relation to the head of state, independence except in relation to the currency, and independence except in relation to the Bank of England.
It can mean several things, but but there's also some things that it clearly doesn't mean, I think. So, so a referendum that didn't ask a question which had anything to do with independence, I think, would not fall under Section 30, although there would be a question about whether that is, in any case, something that the Parliament has the power to do. The issue about does one of the answers have to be no? I think it's a much more tricky question. I don't think that's a reasonable reading of the order, but I recognise I see where you're coming from. That's as much as I'm willing to say.
I suspect that the difference between Article 3 of the order, which talks about a ballot paper that gives a choice between two responses, and Article 4, which refers to questions, is framed in that way because of the language that is used in the Political Parties, Elections and Referendums Act. I don't know that. I would have to check that, but I would suspect that that may be the case, and there's therefore an attempt to ensure that Article 4, which is modifying and applying provisions of what is slightly uncomfortably known as PAPIRA, actually works in this context. So I think that's in a sense a drafting point that is perhaps ever so slightly uncomfortable, but is what's necessary to make something work, given the framework it's operating in. I think, as I said in my memorandum at paragraph 12 and to a degree paragraph 13, the criteria which the order requires for the referendum ballot is that it must offer two options and only two, that those could be framed as statements. I agree that Scotland should have X, I do not agree that Scotland should have X, or I agree that Scotland should have X, I agree that Scotland should have Y. Those would be options, and one of those, let us say X, has to be about independence rather than something else. In principle, I suppose it would be open to have a referendum in which X was independence and Y was some form of enhanced devolution, and that there was no status quo option. I think that would cause quite serious problems in two respects at least, quite possibly others. But one would be issues relating to the intelligibility of the referendum question, because, as I note, the criteria that are used by the Electoral Commission in assessing intelligibility are not simply to do with the ability to understand the wording, but they're to understand the propositions behind the wording and the neutrality of that. So the neutrality would, I think, normally mean that you have a yes-no option rather than a yes and option. The other is that the other problem that I think you would throw up with that potential approach would be the question of who would then be campaigning on each side. And that would then potentially trigger difficulties in relation to having designated campaign organisations, which themselves then are important for the broadcasting and the mail shots. And that takes you back to the problem that arose in Wales.
It just seems to me that there's political agreement between the two governments that what's required is what would be commonly called a straight up or down, yes or no, in or out, independence or the status quo referendum. But it seems that the Section 30 order doesn't actually specify that.
Yeah, can I just add to that? I mean, I think talking about what we were talking earlier about, does the agreement have any legal status? And I think one way in which it can have a legal influence would be in terms of an aid to interpretation. And the clear analogy is with the Belfast Agreement, which has been used as an aid to interpretation of the Northern Ireland Act. So, you know, there's a very close parallel. And I think if this question were, I think I'm firmer on this, if this question were to come before a court, I think looking at the background of the agreement, I think that would be a very strong argument for saying the reasonable interpretation of what this was intended to mean was a yes-no option on independence, whatever independence means.
Okay, thank you.
Well, obviously, we'll have the drafter of the report will be with us soon. It's a reasonable question to ask in the drafter. Patricia, I think you wanted a question in this area as well.
Just add one small point. I'm sorry.
Sorry, I'm conscious of the time here in case of other issues. Patricia?
Yeah, sorry, this might be becoming a little bit too esoteric about it all, but I just wondered whether there's any significance or difficulty in the fact that paragraph 6 of the memorandum states that the order enables the Scottish Parliament to legislate for a referendum with one question on independence, whereas Article 3 of the order states that there must be only one ballot paper at the referendum and the ballot paper must give the voter a choice between only two responses. I mean, it just, in terms of intelligibility, it just seems to me it would have been smarter, perhaps, to have the two more closely reflecting one another.
Possibly so. I mean, the further point I was going to make in relation to Mr. Harvey was this: that there is a tension here between the various objectives that the two governments set for the referendum. The objective that a referendum be made in Scotland and therefore enable maximum discretion to this Parliament to decide the referendum, the process of the question, the referendum, the question and so forth, on the one hand, and on the other, ensuring the fairness in particular, of the fairness part of the legal, clear, fair and decisive criteria set up by the UK government, which entails the involvement of the Electoral Commission. And it seems to me that what you have as a package here reaches an effective compromise between those two positions. It ensures that a referendum can be made in Scotland while being subject to overarching procedures and mechanisms that will assure its fairness on all sides.
Okay, I'm conscious of the time we're at. I'm going to ask Tavish Scott, I think Stuart also asked a question. You've got a new area, Tavish, I think.
Well, I was just intrigued, particularly from the perspective of that our witnesses have this morning, as to whether you believe that the passing of the Section 30 order by parliaments, both here and in London, will change change in any way the investigations that Scottish government officials, civil servants, can undertake into reserved matters.
Well, I think in any statute there are express powers and there are implied powers. So there are implied powers to do that which is necessary in order to facilitate achievement of the express object. So if it is necessary for civil servants in the Scottish Government to undertake those kind of investigations, then I think there is a case for saying that they have the implied powers to do so.
But do they have the implied powers now, or only when the Section 30 passes?
Well, that takes us into the question of what the effect of the Section 30 order is. Is the Section 30 order to confer power, or is it to confirm power?
Well, the logic, therefore, would be that they would have those powers once this Section 30 passes.
If it is to confer power, yes, although it seems to me an excessively legalistic approach to say, well, you can't do things in preparation for something that you think is going to happen and that you as a government want to happen. I think the courts, if we have to distinguish between two questions. One is, are these kind of issues likely to come before a court? And unfortunately, the answer is possibly yes, because there are people who have interest in bringing these issues before courts. But the second question is, how are the courts going to respond? And the courts, judges are not stupid. Well, not all of them anyway. So, you know, they don't want to get embroiled in political questions if they can avoid it. And they don't want to be accused of throwing spanners in the works. So, on the whole, when you get to issues of great political sensitivity, the courts will back off. And particularly if all that you're talking about is a technical objection, like you've done this slightly too early, or you've done it by slightly the wrong process. I just cannot see a court striking down decisions in those kind of contexts. And again, the Robinson case, which I mentioned earlier, which was the case in which the Belfast Agreement was used as an aid to interpretation of the Northern Ireland Act, there you have actually quite a significant departure from the wording of the Northern Ireland Act in order to maintain a political process. So I don't think it's very realistic to expect successful judicial challenges in any of, to any of this stuff.
Stuart.
and then we'll come to James. And
do you want me to?
Yeah, I'd quite like to hear Mr. Trench on this.
Sorry,
as well.
apologies.
I will be brief. I would use a different set of reasons to Professor McHarg in arguing to broadly the same conclusion. That the Scottish Government has always had extensive implied powers to deal with a variety of issues affecting and touching on reserve matters indirectly, if not directly. The international development support for Malawi in particular that was started under the previous Labour-Lib Dem coalition government is, I think, an example of the extent to which, as it were, there is some give in the settlement, and always has been. I would incline to the view that this order will be a conferring rather than a confirming order, but that nonetheless there has been a power to do that which has been done so far, and that power is slightly but not hugely increased by the extent to which the referendum becomes within legislative competence of this place.
Thank you, Convener. Just as a brief question, it's also one I'm posing for the millions of non-legally trained people in Scotland. We've heard a lot this morning, but just for the sake of clarity, I mean, this Parliament can't amend this proposal. We can either pass it or reject it. So, with that being the case, is this Section 30 order, is it fit for this Parliament to pass?
Yes. It does what it says on the tin.
Professor?
Well, what's the alternative?
Okay, well, I don't think we'll go down there at this stage. James?
Thanks, Convener. Just a question to Mr. Trench. You put the point of view forward in your paper that the Section 30 order was required because the Parliament didn't have the legislative competence in order to hold a legally binding referendum. Now, as part of the Section 30 order, the amendment includes, setting an end date for the poll to be concluded, to be held by the 31st of December 2014. Is it your view then that if that doesn't take place by that date, and the Parliament then tried to hold a referendum post the 31st of December 2014, it would be acting out with its legislative competence?
Quite straightforwardly.
Okay, any more questions? In that case, yeah, sure. We've got time for a very, very quick one.
It's just that Professor McHarg, I had read her blog on dealing inter alia with that point, and I think Professor McHarg took a slightly different view of the current scenario.
Yeah, I mean, my view is that the current legality situation is arguable. I think there is an arguable case for saying that this Parliament already has the power to hold a referendum, but it's not an open and shut case. I think the passing of a Section 30 order logically makes no difference to that situation. In practice, it might do, because if I were arguing on the other side, I would say, oh well, look what happened for the 2014 referendum. The Scottish Government conceded that it needed a Section 30 order. So purely on from the point of view of apparent weight of arguments, I think this makes a difference. In terms of the logic of the situation, I think there remains a case for saying the Parliament still has the power to hold a referendum.
Well, we can have a couple of minutes at this. I've got lots of questions around it myself, but Patricia?
Thank you. But would a referendum in the circumstances you describe be legally binding?
I don't think any of I mean, it depends on who you're talking about binding. I mean, you're talking basically about binding the UK government, and this Parliament clearly cannot, under any circumstances, under the Section 30 order or any other circumstances, enact a referendum which actually binds the UK Parliament. It could purport to do so, but it couldn't actually do so.
There's simply no way that any pre-legislative referendum can be binding. There are post-legislative referendums can be, as in Wales in 2011 or here in 1979. But a pre-legislative because you declare in the statute that calls it, the certain things will follow the outcome. But there's simply no way you can do that in this instance. Any referendum will be advisory. That does not, in my view, and others do disagree, bear on the issue of whether it's within legislative competence or not. If the pith and substance of the referendum relates to a reserved matter, in my view, then it would be out with legislative competence here.
You still want to follow up? Okay. In that case, thank you very much for giving your evidence this morning. I'm very grateful to you. We'll have a very short 5-minute break before we see the Secretary of State. Thank you very much again. Good morning again, committee. I'm glad we're about to start the second part of the witness session this morning, and a very warm welcome indeed to Michael Moore, the Secretary of State for Scotland, particularly following the signing of the historic Edinburgh Agreement, and to Laura Crawforth, the Head of the Constitutional Unit, and Chris Flatt, who's the Deputy Director of the Corporate and Constitution in the Scotland office. So welcome, and I'm glad you're here. Do you wish to make any opening statement? Are you happy to just go into straight questions? Up to you.
Other than a brief welcome for the opportunity to be here, and personal thanks to you that I'm happy to put on the record for all the work you did in your previous role in helping us to get to the stage we're at today. An awful lot of the discussions between the UK government and the Scottish government are often seen as being in conflict or otherwise, but I'd like to pay tribute to the fact that in your previous role we worked very constructively together, and I'd like to say that what we've reached here is in no small part due to the work that you did.
I'm very grateful. I'm very humbled by that as well, and I would say back to you, I thoroughly enjoyed working with you in that regard, but we're now in a different perspective.
But today you have a different set of questions, yes.
A different place and a slightly different mode. With that said, though, we'll just open up to questions. Who wants? James, you want to start off?
Thanks a lot, Convener. Welcome to the committee, and thanks for coming along to give evidence. You'll be aware that there's been some discussion around the legal standing of the document known as the Edinburgh Agreement. Would you accept the position that this document is a political agreement and has no legal standing?
If I may put a small preamble to my response, Mr. Kelly, for me, I think what we need to recognise is the historic nature of the agreement. Scotland's two governments working through the differences that we had about the way we should make our way to a legal, fair and decisive referendum, presenting now to both parliaments the proposition that there will be a referendum on a single question on independence, and that alongside that the normal rules and approach to guiding a referendum process, to monitoring it, will be in place as well through the use of the Electoral Commission. And I think that what we have set out through the draft order and also through the detail of the agreement between the two governments is a very important way forward, and I think gives very strong political underpinnings to the referendum that is now to take place. In terms of the agreement, I would say to you that it has the same standing as other agreements between governments, and of course we now both need to be seen to honour what is within that agreement.
I repeat my question. Do you accept it's a political agreement and has no legal standing?
I think it's not the legal standing. The formal part of this will be the Section 30 order. What is beside it is an agreement between the two governments. I wouldn't undermine it, if I might suggest, by calling it a political agreement. I think it's very important. It's an agreement between the two governments setting out how we want to see the referendum process carried out.
Let me put it another way. Do you accept that the Section 30 order is the legal part of the process by which...
that is the legal transfer of the powers from the United Kingdom Parliament to this Parliament.
And that is if you like, the logical conclusion of the discussions that you had. But the agreement itself is not legally binding. So that, for example, if the First Minister claims that he previously hadn't been able to seek or authorise the release of advice on EU membership post a referendum, then that agreement it's not legitimate to claim that agreement gives the green light for that process.
Well, the First Minister, the Deputy First Minister, any minister within the Scottish Government can make their case on this and have to answer any questions that relate to it. But I'm absolutely clear that the agreement that sits alongside the order sets out the process for this referendum, no more than that. I don't accept that without it you could not have investigated the issues around the central parts of independence, namely membership of the European Union or other international bodies. I heard the Deputy First Minister said that in the chamber here a couple of weeks ago. This document is straightforward, and it does what it says there in very clear language. It sets out the process that the two governments have agreed to, and that's what we will now focus on.
You think it would be reasonable to say, though, in these circumstances, that before the actual agreement was in place, there was no certainty that a referendum would take place? Then afterwards, when the certainty a referendum will take place, provided, of course, this Parliament passes the order, provides a different framework?
So quickly after we were in harmony with one another at the start of the committee, Mr. Crawford, I hate now to disagree with you, but I seem to recall you, the First Minister and others prominent within the government making a very strong case from the then side of the argument that a referendum would take place come what may. And we from our side, as you know, were very keen to see that referendum take place. So from the outset, we're constructive and engaged in the way we went about that. And the agreement we reached and signed here in Edinburgh 3 weeks ago was the culmination of all that work. You and others have been party to draft bills on a referendum, done various different white papers on what independence might look like, what the future of Scotland might look like. That suggests to me that a lot of work was going on already. It wasn't waiting for the firing of a starting gun like this agreement before any of the substantive work could be done. So I'm afraid I don't accept that this was the starting point for all the work that can now go ahead. That it is now happening is good, but this wasn't because of the agreement.
I'm in danger here. If I can go further with this bit of conversation, I'm actually turning myself back into being a government minister, and I'm conscious of the fact I'm the convener of this committee, although I might yet come back to you with some points on that. But I'll hopefully Linda Fabiani can deal with that. Yes.
I just wondered, in the vein of that discussion, what trigger the UK government will use to start seeking legal advice in relation to the rest of the UK following independence?
Well, we've already set out that we have taken legal advice on certain matters relating to the EU in particular. The Advocate General, who's one of the UK government's 3 law officers, has actually made a public speech on this very issue, where he has said, the most likely outcome is that the rest of the UK will continue to be the member state within the European Union, and we are continuing to do work, recognising there is uncertainty about the membership of international bodies, and the Advocate General has a forum of eminent academics and legal minds who've gathered once. They'll meet again in a few weeks' time, where all these issues are being discussed. If I may say so, I think the contrast is between our approach, which has been to look at the issues seriously, compare that with what outside experts are themselves saying, and say where we think the balance of probabilities lies, and we'll keep working on the uncertainties, as opposed to the position which has been the Scottish Government's view, which has asserted the fact that Scotland would continue to be in the European Union and in other bodies, without, it would appear, having looked to get that based on advice internally or externally.
I just wondered if you would let us know when you sought that legal advice and whether you'll publish it.
The legal advice we made reference to the fact that legal advice existed back in August. We don't publish that advice, but the opinions expressed in public by ministers is based on that and other sources of information. We can point to the fact we have that. We've taken the trouble to do that, and I look forward to seeing what happens when the Scottish Government does the same.
So you use other sources of information as well?
I think that's just what I said to you.
Annabel, you're, I think, a question around that general area.
Yes, and good morning, Secretary of State. I would like to take this opportunity to congratulate you on what was really a historic agreement in the form of the Edinburgh Agreement with as between the UK and Scottish governments following the detailed negotiations. And I think it's the historic nature of the agreement that leads on to many other important matters. Looking at paragraph 30 of the Edinburgh Agreement, Secretary of State, the last sentence thereof, which I'll read out again for the benefit of our audience this morning, The two governments are committed to continue to work together constructively in the light of the outcome, whatever it is, in the best interests of the people of Scotland and of the rest of the United Kingdom. Can I ask Secretary of State what you take that to mean?
A straightforward piece of plain English that does exactly what it says there. But what it doesn't do, it isn't some kind of Aladdin's lamp, which when you scour the surface, rub it, the genie appears and you get 3 wishes to get rid of all the awkward consequences of what we would need to work through were we to vote here in Scotland to become independent. What that doesn't say there is that somehow, for instance, within the European Union, we wouldn't have to negotiate both our entry and the terms and conditions. What it does say is that the rest of the UK and Scotland would work cooperatively and constructively together. And that's entirely right and proper.
Thank you. If I may, Convener. So I note that you say that there's really a provision that embodies mutual cooperation and perhaps I could go on to say mutual respect. And in that regard, in our previous evidence session this morning, Alan Trench commented that, in his view, this particular sentence of this paragraph of the Edinburgh Agreement was potentially the most important provision in the agreement. Would you share that view?
Well, I hope you'll allow me to say I wasn't following Mr Trench's evidence this morning. I apologise for my delinquency in that respect. I promise to make myself familiar with it. So let me not judge that with all proper respect to your own summary of what he said. I just simply repeat what I've already offered the committee, that this is a very straightforward sentence. It's a very straightforward paragraph. I don't think anybody could possibly be in favour of the opposite of what this says. So at one level, this is just straightforward stuff, but it's good to have it there. And the Prime Minister, myself, First Minister, Deputy First Minister, were keen to show the people of Scotland, the people across the UK, that we had done this in the spirit of the working relationships we already have, which I referred to with the Chairman, Convener, earlier on, and that we would, of course, respect the outcome and we would work together to work through it. But that's not the same as saying that the rest of the UK and Scotland would have exactly the same interests, that all the difficulties would be disappearing as a result of that Scotland wouldn't have some very serious challenges in working through the terms and conditions of its membership of international bodies. I'm happy for a moment to put to the side the issue of whether or not Scotland would automatically be a member or not. As I've said already, I don't think that's the case. However, at the very least, we would have to be working through what our terms and conditions would be for our farming communities, for our fishermen, our financial regulation, what contributions we'd be making to the European Union and the like. Those are all very serious negotiations. Even if you only call them discussions, I think they would represent big hurdles. Of course, it would all be done cooperatively, but very different interests would be at stake.
Thank you there. Tavish. Sorry, you want back in again? No? No.
It's fine, just next Convener, thank you.
Tavish or Annabelle?
Thank you very much. Convener, Secretary of State, on the European Commission, let's try and keep away from Europe to help my colleagues in the nationalist benches by not mentioning Europe. Could we deal with the Electoral Commission and the role of the Electoral Commission? Secretary of State, what does the UK government understand by way of the role the Electoral Commission will play? I'm obsessed by Europe. The Electoral Commission will play in respect of the referendum, and in particular its involvement, and whether the guidance it produces would be binding, either politically, morally, or in any other way, on this Parliament in respect of its role.
I think we can tell that the annual fisheries negotiations are approaching at the moment. The Electoral Commission is a very, very important body which has, over the last decade or so, established proper authority, credibility for its role in elections and referenda, particularly for referenda testing the question and for setting things like campaign finance limits. The body has always had, and rightly so, complete independence from government. And parliaments have always had the power to disregard its recommendations if they so choose. But I think the telling thing is that at no stage since its existence with regard to referenda, has that been done? So on every occasion where the Electoral Commission has offered advice on the question, that has been accepted. Where it's offered advice on the campaign financing issues, that has been accepted. And I was very pleased when, firstly, the Scottish Government said it would look to use the Electoral Commission rather than create a new body to oversee the referendum. I was further pleased in the agreement that they set out a commitment to follow exactly the same approach to the rules and regulations in the Electoral Commission's role as we, as the UK Government, and our predecessors have done as well. I think they have great moral authority. I think they have got established credibility, and for that reason, I think it would be extraordinary if serious recommendations made by them were disregarded.
Therefore, in that sense, and not giving away, obviously, what were discussions privately between the two governments, between the two respective governments, you don't envisage the circumstances where the advice the Electoral Commission give to this Parliament will be discounted in any way?
I would hope not. I think it would be a very serious issue, and I think it would go right to the heart of the trust of people in Scotland about the process that had been entered into. I mean, I'm confident that this Parliament will look very robustly at the proposals when the Scottish Government brings them forward in their bill in the spring as they plan it. I'm also confident that the Electoral Commission will do its job properly and professionally. I think it's very, very important that the same approach is adopted to the Electoral Commission as has been done in previous referenda elsewhere in the UK. To do otherwise would risk breaking the trust of the Scottish people and would create an unfairness about the arrangements which I think would cause difficulties which don't need to exist.
Thank you.
Annabelle, I think you wanted in this area as well.
Good morning, Secretary of State. It is the case that since the signing of the Edinburgh Agreement, brickbats have been flying around, particularly in the question of EU advice or non-existence of EU advice. And while there might be some minor cases of concussion in the Scottish Government benches, I think the real victim of all this has been public trust and public confidence, which does concern me because it seems to me the process must invite the trust and confidence of the public. And from what you say, Secretary of State, do you think that the role of the Electoral Commission with its independence, its objectivity, is actually a very important way of restoring public confidence in the process?
I think there could be no stronger signal of the Scottish Government's intent on this than to ask the Electoral Commission for advice, reflect on it, and then follow it. In the current, sometimes febrile atmosphere about the build-up to the referendum, that's something we should dismiss, should put to the side any questions about process. That's, after all, why Scotland's two governments have spent so much time over the last 18 months working through the difficult issues so that we could create a process that has the confidence of our parliaments, which we hope we will secure, and, more importantly, the confidence of the Scottish people.
And there also any other questions in the Electoral Commission area? Okay. But at no stage, Secretary of State, am I aware, though, that the Scottish Government has said that it would in any way be involved in the process where it wouldn't take on advice of the Scottish?
No, absolutely. And I also respect the fact that the Deputy First Minister acknowledged that, for instance, on campaign finance, the two campaigns did not exist when our respective consultations got underway, so they will have to be consulted. I welcome all of that involvement. I simply set out what has been well-established custom and practice elsewhere in the UK, why that is so important to this process, and believe that this Parliament will robustly interrogate that process, and I have confidence that you and others will ensure that we have a fair process that has credibility and has the trust of people across the country.
Of course, it's the government itself, when it brings forward its bill, will have a suggested question following discussion of the Electoral Commission. I suppose it's legitimate for this committee itself, when it gets to that process, to consider these issues also.
That's a very important part of the process. I mean, clearly and understandably, it was central to the case that the Scottish Government made through the, at first, the discussions that took place in the public arena rather than face-to-face, but then over time was initially you and then the Deputy First Minister took that process through. But we also said that Made in Scotland is absolutely fundamental to this and that this Parliament should be central to that process. I believe this Parliament will scrutinise those proposals properly, and I also would expect that it will support the role and the independence of the Electoral Commission and follow the advice that it offers.
Okay. Now, Rob, I think you had a general question on the order. I'm not sure if you want to ask the same question to the Secretary of State.
It's probably a good idea to do so because we're talking about a series of linked activities. There was a proposal, first of all, for the independence, the bill, including the referendum. There were assertions being made about the process. The Edinburgh Agreement comes in as a legitimate expectation that it will guarantee things. Do you think that the Edinburgh Agreement ensures that the Section 30 order will be clear and decisive and beyond successful legal challenge?
I believe the Section 30 order establishes that fact, subject to approval by this Parliament and by the UK Parliament as well. That will establish a referendum on independence. It will be a single question, a single ballot, and take place before the end of 2014.
Do you also understand, therefore, that as we move on from into the process of the actual referendum bill, that certainty will become possible for outstanding questions about the way forward? Because we've moved from proposals through assertions, through the Edinburgh Agreement, into the order to make it happen. And that the bill which comes on after that will actually provide the certainty about the opinions that people have on international relations, etc.
Actually, if I understand it correctly, unless I have totally got it wrong about the intentions of the bill will rightly put in place the detail of how that referendum will be determined, how the actual ballot will be determined. It's not going to contain provisions saying, and this is what will happen to Scotland afterwards should we vote yes. So there's nothing. I'm afraid I think it would be dangerous to make a link between this order, this agreement, the bill that will flow from it in due course, and some suggestion that that then means all the complications of international relations and membership of bodies like EU will just fly off.
Steps, we're moving from proposals to certainties, and therefore the white paper and so on, and the discussion that takes place around that, which leads to the referendum bill, will be part of that process, and that we should have a greater clarity at that point.
I'm sorry to disagree with you in such a clear-cut way. I agree with you all the way up to the point where the bill that's presented here becomes an act of this Parliament and therefore has established the question, all the relevant rules that go with that, and establishes the referendum. That we're all in agreement about. We're in a very happy place to do that. Let's get on with it. The substantive issues about what would happen to Scotland were we to become independent, those issues are right at the heart of the debate that follows, that in fact we're already getting into. It's nothing to do with this process here. This agreement, the bill that will come from it, they're all about the process of the referendum itself, nothing more.
Okay, is this in the same area? No. I think in that case, Patrick.
Thank you, Convener. Good morning.
Good morning.
I'd like to talk about the constraint that the UK government has insisted upon about the question or number of questions, what you described a few moments ago as a single question. The 3.4 of the Section 30 order says that there must be one ballot paper, and the ballot paper must give the voter a choice between only two responses. Is it your understanding that that implies that it must be in everyday language framed as a question, or could it be two alternate statements, either of which the voter might agree with?
The precise form of the ballot paper and so on is something that will be discussed and put by the Scottish Government initially to the Electoral Commission and then to this Parliament. But the simple, straightforward issue is that this order provides for a single question to be determined about independence, not about other issues.
I can see that the intention is to have the
sorry.
I can see that the intention is to have the referendum address a single issue, but it doesn't need to be framed in terms of a question with a yes or no answer. Is that correct?
It's going to be a matter for the Scottish Government to bring forward their proposal, but when you take the whole of the order together and see where it talks about a referendum on the independence of Scotland from the rest of the United Kingdom, I think that's pretty clear cut. And that's the basis on which we've come to an agreement and which is now placed in this legal instrument.
Of the two responses which are allowable, why did you not decide that the order should specify that one of them must be the status quo?
Well, there's a difference between the formality of the ballot paper and the politics that will go alongside it. The formality of the ballot paper will be determining the central issue about should Scotland stay part of the United Kingdom or become a separate country. However that is framed, there have been various formulations kicked around, and there will be more, I'm sure, before this process is finished. The politics of this, which we all recognise, goes back to the historic election that took place 18 months ago, where, and I'm happy, I will once again put on the record the fact that it was historic that the SNP secured a majority in this Parliament. Absolutely. And, central to that, yes, I've said it to the First Minister a number of times too, he likes it too. Central to that was the manifesto commitment to hold a referendum on independence. Not on anything else, on independence. So we're actually in the happy position of helping the SNP to overcome a hurdle about the powers this Parliament has so that they may honour their mandate. I'm delighted to be in a position to do that because I think this issue needs to be resolved. Let's get that sorted. Now, there's a separate and powerful debate about the powers of this Parliament within the United Kingdom. Now, if I might momentarily speak, not as a government minister, but as a Liberal Democrat politician, my party has just within Scotland, Willie Rennie's leadership, established a Home Rule Commission which brings forward proposals for further powers. That is a debate we're engaged in, and other parties, I hope, will join us. But the central issue that we've been invited to consider, that we must now resolve, is independence. This Section 30 order delivers that ability. The agreement sets out how we'll do that.
I understand the point you're making about the difference between the political context and the legal. And I understand your own political position. Mine is that I regret that some voters may feel that they're not being asked the question they would like to be asked, rather the questions that politicians, none of whom represent at the moment, not including myself, none of whom represent the third option. There may be people, but we're at the point, if I may, we're at the point where this Parliament needs to decide whether we are comfortable with the agreement your two governments have reached. I've got no stake in either government, but this Parliament has to decide if we're comfortable with the terms. And I'm just unclear why we're looking at an order which doesn't actually specify what we would in everyday terms call a straight up or down yes or no question. Independence comes in degrees. The Scottish Government is proposing independence, as I said in the last session, except in relation to the head of state, the currency, the Bank of England and so on. Independence comes in degrees. Is it not legally possible within this order that the Government would offer two different levels of independence rather than full independence and the status quo?
I invite you to reflect on what you've just said. Two different levels of independence. I mean, this is quickly disappearing into Alice in Wonderland territory. I think we as politicians and legislators in their respective parliaments understand what the central issues that we're trying to resolve. We have, with the Scottish Government and our respective lawyers, pored over the formulation of the words to make sure that we are able to do that. That is what this Section 30 order proposes, and the agreement around it shows how we wish it to be carried forward. There's an entirely fair, legitimate argument. I respect your different position on more powers and independence that can be had. But that's now for the highways and byways of Scotland over the next few years. But we can't, I believe, put these two alongside each other and treat them as if they're alternatives. One is about going our own separate way. The other is about continuing within the United Kingdom, which obviously is the preference I have.
Question.
Very finally, obviously I would like to be offered the opportunity not only for what I might call full-fat independence, including addressing some of those issues around head of state and currency and so on, but there are people who suggest that there should be something else. I wonder if you could just respond very briefly to the proposal by John Curtis that there is a way of offering those various other levels. One question, first of all, should we be part of the United Kingdom or not? And a second question, if Scotland votes no to removing itself from the UK, should we then have a further level of devolution? Why did the UK government find that an unacceptable formulation to resolve the practical questions of clarity?
I have a lot of respect, obviously, for Professor Curtis, so it is with some trepidation that I take issue with that particular approach. My view, I always held as to the discussions we had over the months before the serious negotiations began, was that to put the two propositions on the ballot paper and to suggest that more devolution was some kind of consolation prize, but you could only get access to it if you'd first rejected independence. It was just ludicrous. And the idea, what my party leader would call Rennie's riddle, that if you got 52% in favour of independence, but 75% in favour of more powers, the 52% would trump the 75% in some kind of Alice in Wonderland way, was, I think, completely offensive to anybody with a democratic thread in the body. I just think it was ridiculous. And Professor Curtis offers a variation on a theme, but he doesn't get away, it seems to me, from that fundamental issue. You can't mix these two things up on the ballot paper. We deal with independence. We must. We've got to get right to the heart of these arguments, full fat or otherwise. Whatever. Let's get to the heart of what it is the SNP and others wish independence to be. Let's deal with those arguments. Separate to that, I'm confident that once Scotland has decided to reject independence, of course, we will then deliver on further powers. My party is already actively engaged in that debate. Others will be too.
Just very briefly, Secretary of State, a little sort of technical lacuna. The Memorandum of Agreement, paragraph 6, says specifically that the order enables the Scottish Parliament to legislate for a referendum with one question on independence. But Article 3 of the draft order actually states that there must be only one ballot paper at the referendum, and the ballot paper must give the voter a choice between only two responses, and the word independence isn't mentioned. Now, can I just seek your reassurance that your understanding is a ballot paper will ask the people of Scotland to respond to the issue of independence, and we're not going to be asked to, for example, approve a large statue of the First Minister in Waverley Station or something?
To see the Electoral Commission's response to the question put forward, do you think a statue to the First Minister should be put up at Waverley Station? I don't know that it would fit with this particular thing. Look, the first bit of 3 talks about independence of Scotland. We looked at this very carefully, absolutely satisfied this is about independence. That, I'm sure, will be the review everybody else will take, and the Electoral Commission will interpret this in that respect. But one important point, and I think it's worth repeating, it will be for this Parliament then to determine what comes forward in the bill. This Parliament will still be able to, to scrutinise and determine what happens once that question, once it's gone to the Electoral Commission, comes to this Parliament for approval, in the same way it happens at Westminster.
It's Stuart. And then Patricia Ferguson.
Thank you, Convener. Good morning, Secretary of State.
Good morning.
I asked the question of the previous panel just regarding this order, and I did pose the question for the millions of non-legally trained Scots who will actually be following what's going on, and that is just regarding the order. Is the order fit for this Parliament to pass it? And as a supplementary to that, are you confident that the House of Lords will actually pass the order?
I believe yes is the answer to the first question, and of course I would never be presumptive about their lordships. I do, however, hope that they will support this, clearly. and that will be the argument which my colleague Jim Wallace will put to them in due course, and you know, I will take the process through the House of Commons ahead of that. You know, the two governments through this agreement are now committed to promoting this Section 30 order with a view to getting it passed. We want this to happen, and of course it will be scrutinised in 3 different places, and rightly so. Thank you.
Thank you, Patricia Ferguson.
Thank you, Convener. Good morning, Secretary of State. The Section 30 order refers to the referendum taking place before the 31st of December 2014, or before the end of 2014. In the case that that didn't occur, where would the Scottish Government stand if it were to decide it wanted to bring forward a referendum, say, in February 2015 instead? Would the Section 30 order still apply? So there would require to be separate negotiations to resurrect such a proposal?
It would, well, the Section 30 order would cease to have any effect, and a new Section 30 order would need to be brought forward. But, again, it is clear from what the First Minister and the Deputy First Minister and every Scottish Government Minister I've ever heard on the subject have said, there will be a referendum, and it will be in autumn 2014. Happily, we've been able to agree this backstop date, and I don't see any problems.
That's great, thank you.
Are there any other questions?
Quick one about broadcasting. And I notice in the order that there's a transfer of powers, obviously to allow mail shots, to allow broadcasts, general democracy around about the referendum. I just wonder if you're confident in the discussions you had through negotiation that what we've got is a good enough framework that the Parliament, you know, can agree appropriate ways forward in terms of local democracy for broadcasts and for mail shots, etc.
What we have replicated in the order is the power to allow a campaign broadcast from the designated campaigns to take place. And without that power, the broadcasters couldn't have been required to do it. So that's, I think, very constructive part of this process. Rightly, neither the Scottish Government nor ourselves are in charge of broadcasting neutrality and impartiality. There are BBC Trust or Ofcom who have got those responsibilities. And as we acknowledge in the agreement, it is our view that they should exercise their judgment in the same way they would for any other electoral contest anywhere in the UK.
One final question. When do you think it will become clear from the parties to support the Union about what's on offer to Scotland on additional powers?
Oh, Bruce, you're tempting me into new territory here, but I'm happy to spend another 20 minutes talking about it if you wish. We, as the Liberal Democrats, have set out a whole new paper on it. I'll make sure you get a copy. Be careful what you wish for. We also hear that the Labour Party is engaged in these discussions too. I think what people will look at, if I may say so, is the record of the parties in delivering, first of all, the Parliament, and secondly, the additional powers for that Parliament, which the Scotland Act delivered this year. We are on a journey about further powers and devolution. I can't speak for all parties in Scotland, of course I can't, or other interests, but that's a lively debate. I want to see it happen. I just make this observation. When we created the Parliament, and voting for that in the Scotland Bill back in 1998 was one of the proudest votes I have cast so far at Westminster. And when we gave the extra powers through the process agreed by this Parliament earlier this year, in each case there'd been a big set of arguments in Scotland. Parties had put out their views, others had contributed their thoughts, various stushies had taken place. We then got together. I forget to remind you, without the SNP, who didn't want to participate in these discussions, but we came together, we reached common ground and consensus, and on the back of that consensus, in both cases, the Convention and then the Calman Commission, we, as parties, took that proposition to the electorate in the election. Now, that was a process that, one case took many, many years, another was a shorter period. I think we'll go through the same process again. We're already underway with the ideas being talked about. I'm confident that that will accelerate over time and people will be able to see that more powers will come and that this Parliament will be further enhanced in its rights and its capabilities.
Will it be clear before we get to the referendum in autumn of 2014?
We're working very hard on that, but I mean, every party, you know, that process is an organic process. It's a process that's not for me as a government minister to dictate. What it is to do is for all the parties to do. I mean, I know this would be the wrong moment for the SNP to start arguing about more devolution, but you know, you can contribute to the debate if you wish.
Good for that, but it's just not clear what it's about yet.
Well, no, I'm saying I can sit here as a Liberal Democrat very happily saying we're in the game. We're giving ideas. We welcome others to join in. We're confident that across Scotland people will be part of that debate. But what we're all focused on at the moment is making sure we nail the issues about independence, get that resolved, and get on with implementing the Scotland Act, which, as you know better than most here, has a lot of detail in it, a process of implementation over the next few years.
Yeah, but still we're not clear exactly what will be an offer to the people of Scotland before we get to the autumn of 2014.
You're convener's prerogative.
Yeah, of course you can.
I'm clear we will be putting forward proposals based on what is in our Home Rule Commission. I look forward to others bringing forward their proposals.
Okay. Tavish, by all means.
Thank you very much, Convener. On this spirit that we're now into of a more spirited discussion, would you agree, Secretary of State, that it would be very helpful for the people of Scotland to know whether it is, as Patrick Harvey rightly puts it, full fat or semi-skimmed independence that we'll be dealing with in the referendum?
I think that's the stuff of the arguments of the next
Absolutely.
2 years. Bring it on.
Because the Scottish Government have always said that in the autumn of 2013 there will be a white paper, and the people of Scotland will be absolutely clear of what is on offer. What we can't get today,
absolutely look forward to that.
What we don't have at the moment, and sort of I'm having a debate. I'm supposed to be asking you questions, and let me just finish by saying in these circumstances, I still have not got the clarity I was seeking in these circumstances about what will be on offer. Any other questions?
May I respond? I appreciate the convener.
You've been so nice to me in the past. I can't say no now, can I?
Yeah, I will moderate what I really want to say to this extent. I think that my gentle suggestion would be that the SNP might get on with defining what independence is and what it's about, and let us have the debate around that rather than worrying about everything else. We're well capable of looking after ourselves and bringing forward our ideas. We're already doing it as a party. Others will too.
Okay, but on the basis that I'm not giving you the last word, I look forward to when the union parties come together and provide that clarity so everyone knows what we're talking about and everything's visible and transparent. Thank you very much. That ends this particular committee.